Hazel. Thank you very much indeed. I'll start off by following Richard's line of thought. We live in an age of transformation. They're more profound than any that I have lived in, and probably more profound than any of the periods of legal history that most of you teach. That is because of both the rapidity of the transformation and the nature of the change. And rapidity creates risk. And where the delivery of justice is concerned, risk must of course be minimised as far as it properly can. And that is an important part of the task in which the judiciary in England and Wales are involved. Safeguarding the rule of law by change while preserving certain essential procedural and substantive protections. And so my focus this afternoon in this an age of transformations is what the age of transformation is having on our courts and tribunals. I want to look at planning for change, securing greater access to justice and improving its quality. Transformation cannot merely be concerned with moving from an analogue, paper-based, process-focused justice system to a digital one. In this case, the medium is not the message. It is and must only be the means to deliver the message better. And so what is the message? It has to be greater access to better quality justice. A justice system that best safeguards the rule of law for the 21st century. When Lord Thomas and I came to agreements with the then Lord Chancellor Michael Gove, we identified an aim for our modernisation programme and 6 principles. The aim was to give the administration of justice a new operating model with a sustainable and affordable infrastructure that delivers better services at lower cost in order to safeguard the rule of law by improving access to justice. We were transparent about that aim with the judiciary, with Parliament, with the rest of government. And we identified 6 principles which are the touchstone against which the present Lord Chief Justice, Lord Burnett, and I test and, if successful, implement our projects. They are to ensure that access to justice is accessible to those who need it, which involves necessarily improving it. To design systems around the people who use them. To create a system that is financially viable, using a more cost-effective infrastructure, that is better IT, new working practices, and decent estate. Well, all 3 of those are in part missing, with the effect at the moment that the infrastructure continues to degrade in the absence of serious efforts to do something about it. We sought to eliminate the most common causes of delay and to retain our national and international standing as a world-class provider of legal services and in the delivery of justice. And not forgetting, we wish to maintain the constitutional independence of the judiciary in England and Wales. Let me briefly describe some of the imperatives that guided us and still inform us, because they're all too often forgotten in non-academic comment and debate about what we're doing. We started off with the obvious proposition that access to justice is an indivisible right. There can be no second class, even in, and I would say particularly in, an age of austerity. That was the risk that we faced. We still face it. And that the law administered through an independent judiciary requires effective and efficient governance. They're the twin statutory duties placed upon the Chief and myself. And that necessitates continuing scrutiny of the efficacy of the institution that we're charged to lead, to assure the respect that it needs to function. And the consequence is that we cannot but look to modernise and reform our system. And it is in that way that the judiciary are responsible for ensuring that our system is fit for purpose. And we must do that by placing reliance on evidence-based and tested improvements to our governance of the system and the quality of our decision-making in individual cases. So how are we approaching those aims and principles? Well, let me give you an indication of how my tribunal judges hope to make a dent in the universe. And I emphasise, no one size fits all. What we do in my jurisdictions, there are 65 of them in the General Regulatory Chamber alone. I've given up counting how many there are across all 14 chambers of judges. But what we do may not be appropriate for crime, for civil, and so on. We've plans to change the way we use the estate. We want to provide innovative and digital ways of working, to change and improve the way we lead judges and manage workload, to provide support for the judiciary and our users, to use registrars and case officers to much greater and better effect, to provide assisted digital support for our users, especially the most vulnerable. That is a support service that has never been provided before. So just to echo what Richard said, some of what is being done will change access to justice in a way that is not contemplated in the analogue system. And we seek to improve diversity in the way in which we work, including in our recruitment and flexible deployment practices. By way of the projects that presently exist, and I'll let Susan Acland-Hood show you some of those projects in a moment. These are the ones that affect me and my judges. An online tribunal which provides continuous online decision-making process. Separate online interfaces for users and judges. Intuitive online application systems in place of forms. Online notifications and tracking so that everybody knows which stage of the process you've reached and where the endpoint is. E-filing, online triage and dispute resolution before it gets anywhere near merits-based evaluation. Documentary management and case management, online fee payment, online identification of people, online video hearings where nobody is in the same physical space, and online support services for judges and hearings that facilitate the bookings of judges and estate, allocation and listing of cases, and even such things, important as they are to some of my judges, like leave and expense claims. You wouldn't believe the amount of time I actually spend on that latter bit instead of access to justice. And online services for face-to-face hearings. The presentation equipment you take as the norm in a building like this, but which is far from the norm in some of the older estate. And services for people who need to use them, including the litigants in person who come to a court with a carrier bag from the local supermarket, and a way in which they can have their judgments and orders delivered to them. How are we putting all of that into place? Well, let me first of all go to planning for change. Something called Judicial Ways of Working 2020 has just been launched. Now, since 2005, in England and Wales, our constitutional settlement has been predicated on the idea that delivery of justice is a partnership between two separate but equal branches working together to manage courts and tribunals. That is, the government and the judiciary. This interdependent relationship is one that is manifested in a number of ways. The most obvious and the most important for this purpose is Her Majesty's Courts and Tribunals Service, the body which provides support for the judiciary to carry out their constitutional role. That is a partnership between the Lord Chancellor, the Lord Chief Justice, and the Senior President of Tribunals. Its board answers to us as co-partners, and it is not, as it was historically, simply a means by which the Ministry of Justice manages what it chooses to manage in accordance with its own policies. One consequence of that change in our constitutional settlement is that the duty long placed on the judiciary to lead the modernisation of our justice system is all the more acute today. The foresight of each of the heads of jurisdiction who've commissioned, chaired or implemented reviews has informed the series of documents that were distributed at the beginning of this month by myself and the Lord Chief Justice to all judges, panel members and magistrates. They're the ones called judicial ways of working, one for each jurisdiction. Among other things, they seek the judiciary's views on the programme, on how and in what way we can simplify, clarify and improve our processes through digitisation, incorporate and expand the provision of ADR and ODR, to increase the use of technology and online and video hearings, increase access to justice and provide a more flexible, diverse and skilled judiciary. The documents seek judicial feedback. They're not a statement of a foregone conclusion. The duty to lead placed on senior judiciary is to lead effectively and efficiently, and in my case, and I think I'm the only head of a jurisdiction anywhere in the world to have these duties, I'm also required to do that swiftly and to provide specialist and innovative guidance. So when somebody complains about what I'm doing because it's innovative, they ought to just remember I have a duty to provide it for my users. And it's my firm personal belief that we have an obligation to lead the transformation that the justice system needs to prevent its decline. Genuine leadership is, of course, properly informed. It's open and receptive to criticism, and we should not shy away from scrutiny. Scrutiny, if I may borrow from Jeremy Bentham in this hallowed place, is the best antiseptic. To make better choices, we've sought the views of the judiciary, and we must learn from their skills and experience. One essential feature of this process is the need to develop ways to improve governance, that is, leadership and management of the judiciary. Without that essential step, you will not implement modernisation across the system. If, as it discusses, we're to increase the degree to which judges can be deployed across jurisdictions and can have more and different and flexible ways of working, if we're to take a continuing role in the leadership of the modernisation programme, we must review and continue to improve our governance systems. This means that, as with any large-scale organisation, we must review the way in which we work. Do we have the right systems? Do we use the right processes? Do we have the right skills and training? Is, for instance, the present approach to the running of the courts and tribunals the optimal one? Is the judiciary's internal governance system the best for the demands of today? The great court reformers of the Victorian age did not shy away from these difficult questions, nor should we. Business as usual, in particular our public-facing infrastructure and process, must be improved before we digitise it. This is all the more important if, as has been said, our courts and tribunals in the future will be digital by default and design. To operate in this way, we all need to be properly trained, and we need to have the right governance systems in place. We cannot continue to manage the judiciary on an analogue basis. If we're to manage a digital workload and lead digital working practices, we need better governance arrangements locally with HMCTS and regionally and nationally in our collaboration with government and the legislature. That is unfinished business and part of the 2005 constitutional settlement. We have to better manage our functional and formal separation of powers if we are to protect them. In any event, the process of modernisation casts a spotlight on our existing arrangements, that is, the essential operational means by which we bring the digital world to our justice system. The judges engaged in the governance of HMCTS, we must do our utmost to inform, collaborate and scrutinise what is done in our name. The reforms we've already embarked upon, and which we should consider embarking upon, have that common objective to improve access to justice. This means we must respond to the needs of what has become a digital society. When eBay can deal with 60 million disputes a year, there's a pressing need to ensure that our justice system can operate to ensure that where the individuals involved in those disputes wish to do so, they can access courts and tribunals as readily as they can eBay's dispute resolution system. This is not to suggest that we seek to discourage settlement via ODR. It is to say that as a society, we remain able to secure effective access to justice for all. Our systems must change to meet the needs of today's society, today's citizens, and today's disputes. We cannot afford to create or countenance the existence of digital outlaws, individuals and businesses whose disputes are outside the law's protection. Access also demands that our reformed courts and tribunals and our new systems are accessible and accountable to the public. They must remain open to public scrutiny to maintain the health of the system, to maintain judicial accountability in a democratic sense, and to ensure that arbitrary decision-making does not arise when justice is done outside of the public gaze. Open justice and accessibility for today's disputes is necessary for another reason. If we permit the creation of digital outlaws, we permit the subversion of our substantive law. We do so because we acquiesce in some forms of disputes being beyond the reach of our courts. And in doing so, we accept that some laws cannot be interpreted, applied, or explained by the courts. Such laws would become dead letters. Their interpretation and application would become a matter for private actors, not the public domain. We thus would have to accept a democratic deficit in our society. The modernisation programme is the means through which we ensure that this is a digital age where we do not permit the conversion of public laws and the values they instantiate into private and privately interpreted guidelines. Hence too the need to ensure that online or video hearings, like telephone hearings in the present world, are carried out in the public gaze. Finally, I want to touch on the quality of justice. We're committed to providing the best quality of justice we can. And that does not, as some have suggested, mean that we seek a blank cheque in terms of the allocation of resources to the justice system. It does mean, however, that the justice system must be provided with the resources to enable it to fulfil its constitutional duty. Quite some time ago now, Guido Calabrese and Philip Bobbitt described the problem of the tragic choices society faces when it needs to allocate scarce resources among multiple demands. Each is a valid, a necessary demand. How each society decides to allocate its resources is a statement of its fundamental values. It is a statement of what and who we are as a society. In answering the question of resource allocation to our courts and tribunals, to our justice system, we define ourselves. We define our commitment to being a just society, and so we ought to make good choices. Securing quality justice is not just a matter of resources. Of course, it goes wider than that. Modernisation must focus on how we improve quality. That has a number of strands, and I can touch on only one or two. One of the most important, from my perspective, is the need to ensure that the steps we take to improve quality are systematic, evidence-based, and tested. For example, that there is data embedded to enable each project to be tested and improved over time. Only through rigorous testing can we properly develop good and better practices. Our modernisation programme is making extensive use of pilots. We put in place pilots for e-filing. They were piloted in what are now the business and property courts. Online applications in the divorce and probate pilot schemes in the family justice system. Online civil money claims processes in the civil court system, and online video hearings, sometimes known as virtual hearings, and continuous online hearings are being piloted in the tribunals. As we learn from these pilots, we need to learn from the feedback here as much as anywhere else. We learned a lesson both from going to Holland 3 years ago and more recently to Canada. Let me just take the latter example. Their civil resolution tribunal provides effective feedback on how it is operating in real time to improve the process. We also need to look at judicial decision making. At the moment, we are trained to determine rights. As Richard has pointed out, effective problem solving also involves mediation and facilitated negotiation. These are approaches which my tribunal judges are well used to and very well trained in, but their training needs to be rolled out across the judicial landscape. In conclusion, may I make the obvious point? Justice is not something that is done to people, nor are we a consumer service that the Supreme Court in the Unison case felt moved recently to comment. Justice is, as the opening line of Justinian's Institutes rightly noted, the constant and perpetual wish to render everyone their due. That wish is the duty cast on the state to ensure the effective delivery of justice. The present transformation of our courts and tribunals, of our judiciary, is the means through which we can and must ensure that as a society we can render everyone their due. As I've said before, as a society committed to the rule of law, it's a responsibility we cannot shirk.
Thank you so much, Ernest. There's a huge amount in there, and certainly among the many things I picked up is the fact that there's an awful lot going on in tribunals already. In a way, they're almost leading the way. And one of the things that worries me is the extent to which there are different understandings within the judiciary themselves about where we have got in any stage in this transformation process. And so I am particularly delighted, I'm very delighted about everyone being here, but I'm particularly delighted to have Susan Acland-Hood, who is the Chief Executive of Her Majesty's Courts and Tribunal Services, who has the, I don't even know which adjective to use, the job of overseeing this transformation process within the Courts and Tribunal Service. And I'm hoping that Susan will shed some light on where we are and where we're going. So thank you very much. I'll just try and flip like that. Good. You're right.
Hazel, thank you very much indeed. And thank you very much for having me here today. I'm going to speak a little bit about the programme as a whole. I'm going to try not to repeat too many of the things that Sir Ernest has said. And then I'm going to give you a few examples of some of the things that we've done and try to talk about how those may come together in the future. And all the while I'm going to be keeping an eye on Hazel because I have a bad habit of getting over-enthusiastic and talking for too long. So I will try not to do that. So first of all, as Sir Ernest has said, we have a world-class justice system, but it's not perfect. And there are things we need to do in order to retain our leadership. There are lots and lots of things that as I go around the country talking to people and visiting courts and tribunals, people tell me are wrong with the system as it is at the moment. There are also some fundamental underpinning principles which we must retain. And my underlying belief is that there is no reason for the way we work to be as ancient as our principles. One can have one without the other. By the way, I quite like this picture. I think it's sort of what we're doing. People occasionally get worried that when you start trying to modernise and clean something up, if you stand in the scales of justice like that, they might tip. But you can see they're quite robust, really, which I think is encouraging. A little bit about the system that we're reforming and what the things are that make us think that we might need change beyond the response to Richard's excellent challenge about the way the world is changing around us. We need more than ever, I think, a justice system that leads and inspires the world. But people tell me all the time that alongside the dedicated, enthusiastic and committed people who work in the system, I'm not just talking about my staff, but also about the legal professionals who work in the system, who I see again and again bringing work beyond the call of duty to what they do. The systems and processes that we use in the system are really labour intensive, extremely paper based still, and often ask more of people's work than they can deliver in order to get things out in a timely way. And at worst, we look like we don't understand or respond to or care about other people's time and trouble. And for me, even in the absence of the wider set of challenges around the way the world is changing, that would be sufficient reason to change what we are doing. We also aren't terribly good at making our system and our activities proportionate to the work that is being done, in my view, and that's not just a resource question, that's also about the time that is spent and how quickly people can get to that resolution that Richard talked about, which is the thing that they really want. So just to very briefly illustrate that, that is a genuine picture from one of my courts. Admittedly, it's one where they've got a bit of a storage issue, but that is a filing system. So just in case you can't quite see it, on the back of those window blinds, can you see there's letters? So that is cases filed. This is the civil justice system. Broadly speaking, we still work on paper like that. And when you look at that, what is remarkable about our system at the moment is not that we sometimes lose things, because I'm prepared to confess that sometimes we do. It's that we don't lose more things. And that is because I have extremely dedicated, serious-minded people who understand the importance of what they're doing, who make that work. But this is the picture that comes into my mind when I'm occasionally asked by people, why are you putting all this effort into digital transformation? Why don't you just ask for more resource to run the system better as you do it at the moment? Now, I could ask for the number of people that would make that system work really, really well, but I'm not absolutely sure that that is the best use. I mean, even if I were able to get that resource, I'm not sure it would be the best use of it. So I would rather reform the system and try and make sure the resource is working as efficiently and effectively as it can. So Ernest talked about our guiding principles. I seem to have two more principles than Sir Ernest, which is always a bit dangerous when you're in a relationship with a judge. Sorry about that. I'm not going to talk about all of these in detail, and some of them are obvious. We're trying to make sure fundamentally that we build the system with people at its heart, the people who use it. We are trying to make sure it's financially sustainable. We are absolutely committed to increasing, not just maintaining, transparency and accountability, to strengthening our strong, independent and trusted justice heritage, thinking about what that means. What are the pieces of the system that we must retain in the modern world? And I argue that a large number of those are fundamental underpinning principles rather than pieces of process. We want to be proportionate and segmented. We want to increase accessibility, again, not just maintain but increase. We want to do what we're doing in partnership with others. So as far as possible, we are trying to do all of the things that we do rapidly at small scale, but involving the people who need to use the systems in telling us whether what we're doing makes sense and helping us design them. And then finally, this one about design for 2050, not 2018, which I do need to just spend a couple of minutes on, particularly following Richard's talk. This does not mean that I think that I have now designed some, when I show you screenshots later, I don't mean I think those are going to be the same in 2050. That would be nuts. The one thing we can tell for sure about any prediction I make now about 2050 is that it'll be wrong. And design for 2050 means designed in the anticipation of future change. So one of the critical problems I have with many of my legacy systems in the court service is that they were not designed in anticipation of future change. People put them in, thought that it would be fine for you to assume you weren't going to have to change them very often, and that changing them in the future would be slow and expensive. And I have quite a strong culture of my staff being engaged in continuous improvement activities in the court, and quite often they say, oh, if only we could tweak this or tweak that, we'd be able to do it more efficiently. And at the moment, the cost and overhead of change in my legacy systems is so high that quite often we can't take on those suggestions for improvement. So that's what that means. Overall, what are we doing? Some of you, I know that to some of you this will be completely obvious, but I try to locate what I'm talking about. Just in case it's not for others. We have a programme of reform that affects really everything that we're doing in HMCTS. A crime element that is built around thinking about how cases go through the system in a different way, and is supported by the Common Platform Programme, which gives common IT across police, CPS and HMCTS, with critically the ability to look from end to end. And that ability to see through the system and see what has happened at other stages in the process, as well as to get data and management information out of the system, to me is one of its most crucial aspects. Mainly today I'm going to talk about the Civil, Family and Tribunals programme. That includes the development of better direct services, but also the beginnings of this online court with shared simple rules that has been talked about. I'm not going to talk about transforming compliance and enforcement. I'm not going to talk very much about our underpinning change, although I might just touch on video hearings because they get raised a lot in this context. And I will talk a bit about our data and management information work. Critically, we want our new systems to give us intelligent, connected, open, flexible data that allows us to run the new system better in the future, to draw insight and to make future change. It is remarkable how many things about the system I run I don't know at the moment. And it is also remarkable how many of the things we do in the system we do on the basis of custom and practice, or the notion that many of the things we do are an art, not a science. And I think quite often that art could be better underpinned by a bit of science. It's a very ambitious programme. We did a piece of work with BCG to look at comparisons around the world, and they told us, I don't think they were just being flattering, that it was the biggest and that we were trying to do it the fastest. This sometimes keeps me awake at night, although I do basically think that if you don't do change reasonably fast, it's very difficult to sustain. In order to make that very ambitious programme of change work, we are building components that fit together rather than a single giant system. So this is more agile and it reduces risk. It means we can build small, we can iterate, we can test with real people, and we can generate things which are then going to fit together. I'm not going to talk about this very much more because now I'm going to give you 3 examples of things we have actually done, which should, I hope, help to show what this means in practice. First, divorce. So this is the old paper divorce application. You can see that it's relatively forbidding, I would say. It's 15 pages long. I haven't given you all 15 pages, you'll be glad to hear. It requires you at various points to know things like the difference between your domicile and your habitual residence, which you can probably do, but lots of people can't. At the moment, we send about 40% of them back because people have filled them in wrong. So not because they're not eligible for divorce, but because they made silly mistakes, essentially. And this is I'm not talking about financial remedy here, I'm not talking about sorting out your money, I'm just talking about the business. If you and your husband, you both want to get divorced, you have to fill this form in order just to get the divorce part. That's all we're talking about. 40% sent back, filled in wrong. This is our new online service, which you may have seen in the press we launched in what we call public beta. So this is still a service which we're testing and improving, we're getting feedback on. We launched it in private beta last summer. So we've been running it with small numbers of invited users. And the system takes you through step-by-step a number of questions that asks you about your divorce, your reasons for divorce. This is the most exciting page because it allows you to click a radio button for adultery. The rest of it's much less exciting. When we first looked at how this had affected that error rate that I was talking about, last September, so we'd been running it for a couple of months with a small number of invited users, we found it had taken the error rate down to 8%. And that's essentially because it does this. If you fill in something wrong, it tells you and it asks you to do it again. This is not rocket science. We have all seen this in services we use every day. It also allows us to look collectively at the reasons why people are getting things wrong and change the way we ask the questions. So 8% in September, down to 5% by Christmas. At that point, we're still running a print and post service where people fill in the form and then they send us their marriage certificate. Just in January, in the private beta, we added upload your documents. So this allows you to take a photo of your marriage certificate and upload it rather than posting it to us. And that really brought the error rate down. So from January onwards and now into the public beta, that error rate is running. It fluctuates a little bit because we're down to such small numbers, but it runs between 0.5 and 0.7%. So I'm just going to pause on that very briefly. 40% to 0.7%. Take the upper end of the current range. We haven't done anything particularly radical here. I'm not going to claim that this is bleeding edge technology. It's not. But it just makes it easier for people. And it saved an awful lot of my staff's time. We were really worried about this upload thing, by the way. This back on the point about digital competence. We thought people wouldn't cope with this well, people wouldn't understand it. It would be difficult for them to get the images of good quality. Currently, we are at a 90% success rate for uploading your marriage certificate in a quality that we can read and that we're happy with. My staff then get a nice view that allows them to process the cases in the background. We thought we were going to have to do some dual running with legacy systems because until we've done the entire end-to-end process, including financial remedy, we have a legacy system called Family Man, which remains the system of record. I know, sexist, I've got Case Man and Probate Man as well. Anyway, so I thought I was going to have a little hump in stuff where I had people typing things from the nice new case management system back into Family Man, and actually we've managed to use a bit of robotic process automation to do that, which I'm also very pleased about. So we're just trying to all the time find new ways of doing things that make it easier. So this saves my staff a lot of time. Staff spend about 13,000 hours a year dealing with paper divorce forms, and so we can cut that. We're not redoing all of those 40% of the forms. It's faster anyway. It takes people about a third of the time users about a third of the time to fill in the online divorce form as the current form. And so this description that was given of a system that starts with good quality ways of collecting information from people, we can demonstrate now that we really can make this process a lot simpler and easier for people in a way that works, that makes the system more effective for the user, cheaper for us to run, and allows us to do things more fleetly and efficiently. I'm not going to read out the quotes, but we really do, the satisfaction rate is running in the 80s as well. Second example, civil money claims. So this is, again, a system that we've very recently taken from private beta into full public beta. And this allows you to online issue in response to civil money claims under £10,000. We also have a version that's specifically aimed at solicitors using it. That's not yet in public beta. It's still in a small-scale trial. We put this out publicly just before Easter. And again, there are some very simple reasons why this is helpful. So the first thing is it's quite quick. So you issue your claim. If you know the email address of the person that you want to claim against, then it sends them an email, and that happens instantly, whereas in the current system, so we do have money claims online. We have a thing that is a sort of online system. Basically, that spits out paper, and then we process it as if it was a paper application. This is much more efficient than that. On Maundy Thursday, we had somebody make a claim at about 2 minutes to 2 and get paid in full by the defendant at 4:01. So best case scenario in the paper system, that would be in a post box. Best case scenario in old money claims online, we'd have printed it out and put it in a pile. Again, the bits of the system that don't need us to do lots of manual processing in order for people to get resolution, we can make much simpler and more effective. We've tried to go a bit further than that, though, and offer people prompts to resolve the dispute. We offer telephone mediation, and we've offered people links to that. We give guidance on what people should do to resolve the dispute before they go through the process. And then we also, so this is notifying the defendant, we also give people the opportunity to make an offer. So this is without prejudice. It's outside the system at the moment, and you can say, I'm not admitting liability, but I'll give you half, or I'll fix your car, or I'll make you a new cake, or whatever it was, and make that offer back to the claimant. And if they accept it, then it tells you that you've settled, and it turns the agreement that you've made with each other into a settlement agreement which you can keep and act on later. And that is genuinely novel. We didn't have anything like that in the old system, and it is being used. We've had 7 people reach settlement since Easter. It's very small numbers, but it is genuinely something that we haven't offered people the opportunity to do before. And we're also seeing people use this in quite an interesting way in combination with mediation. So people are ringing up, having telephone mediation, and then using the system to record where they've come to. And that's also, I think, quite interesting and starts us down the road of genuinely different ways of getting resolution to disputes. Again, the feedback is incredibly positive. I'm particularly interested in quotes of the form of the second one. If I'd known how easy it would be, I would have made the claim ages ago. I think that this and systems like it will bring people into the system who have not contemplated using the law in this way before. And I certainly reflect about myself that if I felt that I'd been ripped off in a small way by somebody, the bar that I would have to hit in order to take someone to the county court would be really quite high. But actually the bar you need to hit in order to start a claim on this system and see what happens is relatively low. And I think that's got the potential partly to address the challenges that Ernest was raising about trying to make sure people aren't going outside the law for resolution into places that are less well governed, less transparent and less able to flow back into our common law, but also just to bring a huge number of frankly kind of small scale rogue traders into greater jeopardy, and I'm quite interested in doing that. I mean, if you rip lots and lots of people off in a small scale way, at the moment you're in much less jeopardy in our system than if you rip one person off in a large scale way, and I don't think that's inherently obviously right. Third example, social security and child support. This is a system that allows you to submit your appeal online. This is still in private beta, but it effectively flows through directly into us, and then we're able to move the appeal to DWP more quickly than in the current system. Again, it's structured, it helps you answer the questions, it doesn't allow you to fill in things that aren't right, so it helps you get it right the first time. We are getting these appeals into the system much more quickly than those that come to us on paper. This also comes with a facility to track your appeal and find out what's happening. And this is in national rollout now. So this is available nationally for PIP appeals. And the reason that we rolled out track your appeal before submit your appeal, which seems a bit odd, is because that's what users told us they wanted. So when we asked them, they said, yes, we'd like to be able to submit our appeal online, but what we really want is to know what's going on. And we have hundreds and hundreds and hundreds of phone calls to our phone lines that are just someone saying, I don't know what's happening, tell me what's happening, what's going on, where is it up to? And we can give people the ability to log in and find out. They get text messages that tell them what's happening. They can sign up for email alerts. Text is generally more accessible than email to more people. There's very few people now without a SMS-enabled telephone. We get, again, really positive feedback on the ability to track your appeal. I'm now going to move into the bit that's much more exploratory. So those things are all out there at the moment being used with real people to some degree or another. Most of them in public beta. The submit your appeal still in private beta. We'll expect to take that out more widely later this year. This next bit is our first foray into thinking about what has been described as continuous online resolution. And I will say that this is a tentative step, and I will also say I have not shown these slides to anybody yet. So this is the first time. This is a very much a kind of alpha system. It's not out there. We're just starting to think about very small scale trial. Sir Ernest has seen it. John Aiken has seen it. But I'm not standing here telling you I think this is right yet. I'm just telling you that we're working on it. And I think there are certainly some things about it that we need to develop further. So this is, you're making your social security appeal, and the tribunal tell you that they want you to answer some questions. So they email you and they say, we need some more information to help you to help the tribunal make a decision. There'll be straightforward questions, and you have to sign in and answer them, and it gives you a deadline. This is the judicial interface, so the judge can create a question. We've been doing quite a lot of work on how we structure those questions so they're intelligible, having a bank of questions that people can adapt and so on. I think there's quite a lot of work to do here as well. And then this is what you might see when you were responding to that. So this one says, you've told us you avoid interacting with people. We'd like to know more about the times when you see your friends and family. Tell us about 3 separate occasions that you met with friends and family, what happened, how you got there. And this is a fairly this is a fairly sort of classic social security tribunal question that people might get asked. And you see you've got the facility to type your answer, but also you can record your answer by audio or video. So you can make a clip that you can send back to the tribunal. And then, the way we're looking at this now is that the tribunal, there's some really interesting questions that this raises that we're starting to grapple with. So how many times do you let the tribunal come back and answer a question? Well, people don't have the patience. It's not reasonable to ask people just to stand by their beds and answer hundreds of questions as they occur. So we're looking at, for example, 2 rounds of questions, and then people have to make their mind up. You can batch questions. Again, we're looking at, you shouldn't ask people sort of 94 questions. If you've got that many, you should have a hearing. But we're starting now to do very, very small-scale lab tests with people looking at this. And again, the responses are quite interesting. People quite welcome the opportunity to think about how they're going to say what they're going to say. They actually, in some cases, find it less intimidating than the thought that I have one shot in a tribunal. It offers the opportunity to do things like, if the panel's asking you questions about how you get around, you can upload a picture of your walking stick. So they've got that to look at when you're talking about, this is what I use to get around. I think this is a really interesting next stage of the development of the work that we're doing to give different routes to access justice. And we should be able to talk a bit more about how this is working in practice as we start to do it. Again, we'll start very, very small scale in a very controlled way to test and look at this over the next period. And I very much welcome thoughts, reflections and questions on this part of the process. You may be able to see how some of the pieces that I've just described might start to come together to respond to Richard Susskind's challenge that we should create an online court that is affordable, quick, intelligible and proportionate. And you can see that we've got some of those elements already in development. The initial submission of your statement of what you want to ask the system to do through those kind of better structured forms. The ability to look at how you resolve your disputes in different ways by starting to iterate between you and the other party in civil money claims, and then the ability to talk to your tribunal in a different way through answering questions from them and being able to give them evidence in a range of different ways, including asynchronously rather than at a single moment. And I think the key thing here is that we don't think that there's a sort of one-size-fits-all that will fit everything, but we do think that there are some components that we can use across different parts of the system and fit together in different pathways that we think can be made to work. And we also think there's learning we can get across the system. And we're just in the stage now of starting to put some of those pieces together, build that learning and look at where we're going to go to next. And I think this is genuinely a really quite exciting time. I'm conscious of time so I'll try and move forward. I wanted to talk about one more thing, which was video hearings. So again, this is a topic that raises many questions for people, and I just want to talk a bit about what we've been doing. We have carried out so we use a lot of video in the criminal system, typically to have a small number of parties, so quite often just the defendant, sometimes the defendant and a witness or two, appearing by video in what is fundamentally a traditional courtroom setup. One of the things that we are starting to test is what we describe as a fully video hearing or an online video hearing where everybody is appearing on video. And there's quite interesting research from the world of business that suggests that actually if you want a really level playing field in your online meeting, you're better to have everyone online than to have some people in the room and a couple of people beaming in, which I think may not be transferable, but I think it's an interesting question. We started by looking at testing a couple of these in the Immigration and Asylum Chamber for preparatory hearings that didn't involve the appellant, so effectively bringing lawyers together to talk about how they were going to manage the case, and got very good feedback on that. And you can see the use case for that, which is that people don't necessarily need to travel in order to do that preparatory work. It's quite often forgotten when we're talking about online video hearings how many of the hearings we still have in court are in that form of preparatory hearings that don't involve the litigant or the appellant themselves. We're now trying some hearings in the tax chamber that do involve a litigant. And again, you can see that we've chosen a place where we're reasonably confident of having people who will not have lots of vulnerability. Although what's been very interesting about it is that actually some of the people who have opted to have, so we've written to people and said, would you be interested in having your tax hearing on video from your home rather than travelling? And what's been quite interesting is that some of the people who have opted in have been people who had a reason why they didn't want to travel, which was sometimes a vulnerability. So we've had people who found it had difficulty travelling. We've had people who didn't want to travel close. We had a pregnant woman who didn't want to travel close to her due date, for example, who said, actually, I'd really like to have a video hearing because then I won't be worrying about whether I'm about to give birth in a tax tribunal. Sort of makes sense. And we've only done a very small number. We're doing a lot of learning. We've made sure that we've put in place evaluation that looks at people's experience of the pilots as they go through them. But early doors, the first few that we have done, the biggest problem that we had in the first one was that HMRC's Wi-Fi didn't work very well. The litigant was fine. They were at home on their laptop, and that aspect of it worked absolutely seamlessly. So apart from doing a bit of work with HMRC on their infrastructure investment, we think that there is something here that we can certainly build on. And I think that, again, the final thing I would say is I'm interested in giving people new routes and new ways to do things, not in replacing one monolithic way of doing things with another. So I think at the point where we decide that everything's going to be done in a particular way, we risk repeating the mistakes of the past. But there are certainly some things where you can see huge advantages in moving to this way of doing things. And I would say particularly for progress hearings and for appellants and other litigants who've got a reason to want to do it in this way, or who want to be heard more quickly. The final two things I wanted to talk about are insight and evaluation, and how we fit into a kind of wider ecosystem. So on insight and evaluation, we are absolutely clear that we need to be doing things in an evidence-based way. And that is sometimes challenging when you are doing something new and trying to work out how people are going to respond to a different way of doing things. So I said to you that we've had some people reach settlement through that settlement agreement that we put in place as part of the civil money claims pilot. And we genuinely didn't know if anyone was going to use it until we did it. And if we had waited until we had evidence that people were going to use it before we built it, then we'd never have got there, I don't think. So there's a certain extent to which we have to structure the way we're working such that we can do this careful, small-scale rollout and testing before we go more widely with anything, in order to allow us to test novel things. And so the whole of the way we're working is built around trying to gather that user feedback and respond to it. Again, as I described in the section on divorce, finding out which bits of it are not working for people and changing and tweaking them until they do work. And that's absolutely kind of hardwired into the way we're working. I mentioned we've also commissioned independent research into the first area to trial full video hearings, those pieces of work in the tax tribunal. It'll be principally qualitative, but we're also looking at whether there is more quantitative evidence that we can draw out of what we've already done on video. We've got a dedicated strand of work focused on MI and data, which I spoke about earlier. And we're also, with the Ministry of Justice, developing plans for programme-wide evaluation of courts and tribunals reform, because doing it project by project is important, but understanding the impact on the system as a whole is equally important and cannot necessarily be done through individual pieces of strand-by-strand work. And I know that's something lots of people in the room will be interested in and may want to ask about. And I welcome people's input and suggestions into how we should be doing that. The final thing I wanted to talk about was around, I've said creating an ecosystem here, and that may be a bit grandiose, but creating and interacting with an ecosystem. So I also think that we need to think quite carefully about how what we're doing fits into the wider world of law tech and law tech development. And we can learn here from other things that have been done around government. And I've been looking quite carefully, for example, of the way HMRC have worked to make sure that the changes that they've made in some of their systems and processes are open to other bits of innovation in the fintech world. And this can be as simple as making sure that we have intelligible and clear APIs that other people can notch onto. And there's a whole kind of other talk that you could do about, in this future, which bits of this world rightly live within the boundaries of the state and which parts of this world live outside the boundaries of the state but need to be able to translate across. So I've had people talking to me about things like Polly, the digital divorce assistant, and I don't think I should be trying to recreate Polly inside the state, but I do think Polly ought to be able to fill in my form because that makes the world more helpful for most people. So trying to figure out how I make myself porous to those developments without ending up but neutrally porous to them, if that makes sense. And I think if we do that right, then we can help to be part of the catalyst for the development of really good quality law tech in this country, and that's something I'm also really interested in. I'm now getting the evil, so I'm going to stop talking. We know that we can't do this on our own. We know also that we're not always that easy to interact with. The programme is huge and complicated. It's got lots of pieces to it. It takes me 20 minutes just to explain it. There's lots of people beavering away trying to get things done. But we do want to hear from people, to continue the conversation, to get people involved in what we're doing. We've got a blog. You can tweet me. Many people do. And we've also got an email address, and if you've got particular parts of the programme you're particularly interested in, if you email and say which bits you'd like to be connected with, we've also got a whole set of things below that level where we can connect you with individual pieces of project and programme. And I'm also happy, I do as many of these types of engagements as I can in order to make sure that we're talking to people and hearing from people as widely as possible about the reform. So available for weddings and bar mitzvahs. And we will always make sure someone, if you've got something that you're doing where you would like someone to come and talk about this, we will make sure that someone can come and do that. Thank you very much indeed.
Susan, I really want to thank you for a fascinating presentation, for being prepared to come and share with us what's happening, but what's also in design at the moment. And what you have done is to confirm for me, I said before that there's a real problem even within the judiciary about people knowing what's going on, but you have confirmed for me that there are genuinely revolutionary changes beginning to take shape, not least the idea of the asynchronous processes with Java's online. And these are fascinating developments. I was also extremely pleased to hear you say that you're absolutely committed to a programme of research on these areas, because we're going to need to work together collaboratively in order to achieve that. So thank you very much for coming. I'm sure that the audience really appreciated that, and you will notice I gave you some extra time. Now I want to hand over to Joshua Rozenberg, very well-known legal commentator who has taken a particular interest in the development, in digitisation of courts, the development of online courts. Joshua, here's your opportunity to...
Thank you very much. Very brave of you to invite me. Journalists don't usually get invited to events like this, little invited to speak on the opening panel. So why am I here? Well, 2 years ago, and there is a slide which maybe I can... Good. 2 years ago, I came to the conclusion that the development of online courts in England and Wales was a huge and exciting story. It was a good news story. The government was spending £1 billion on the project. It was definitely the right thing to do. So I resolved to try and cover it, and I published a paper about the reform programme. That's the one on the left of the screen, the online court. It's been regularly updated. The latest edition came out last Thursday. It's available to download for a small fee on Amazon, and the Legal Education Foundation are planning to publish it without charge. It's mainly about England and Wales, but it also has a small section on British Columbia, which you will hear about in the next session after the break. I also agreed to deliver a series of 3 annual lectures at Gresham College. These have full images, every slide you can possibly want. There are no more slides than this. It just stays up for the next quarter of an hour. That lecture, the second annual one was in February, and the final one is next February. And in it I made a number of suggestions, and you won't be totally surprised to know that my suggestions have been totally ignored by HMCTS, but I'm afraid so have Richard's suggestions, which I think are rather more valid. If you look at Susan's slides, there were 2 things that struck me about them. One of them was the question that you're asked if you're seeking an online divorce, and she pointed out that she'd chosen the one about adultery. I think the actual slide, because I looked it up myself last Thursday, I didn't actually go so far as to get a divorce, but at least I went some way down the road. I looked it up last Thursday, and the actual question that you're asked, if you've identified yourself as a man, as a husband, is this. You're asked to choose a reason for your divorce, and one of the options is your wife has committed adultery with a man and you find it intolerable or unbearable to live with them. Now, nobody would be surprised if a husband found it intolerable to live with his wife and her lover, but that is not something that the courts need to know. What the question is trying to find out is whether a wife had committed adultery and a husband found it intolerable to live with her. There is no need for gender-neutral language if the person concerned is a man, because he is, in these circumstances, divorcing a wife, and it is perfectly possible to say her. Now, that's a perfectly small, trivial example. Let me give you another rather more serious example. If you look at all the slides that Susan showed, they were all headed gov.uk, gov.uk, the Government UK website. Now, is that acceptable for a court? Look at her letters that she said, very much a draft, but one of them was about the Department of Work and Pensions, and it said, here is the panel, this panel is independent of the Department of Work and Pensions. And yet that letter which Susan showed is headed Gov.uk. And you, the person receiving that message, are meant to believe that the person who is writing to you is independent of the government when it's headed Gov.uk. You are meant to believe that the courts are independent of the government because you may be taking the government to court, and yet it is headed Gov.uk. What should it be headed? Well, of course we don't know because nobody's decided what the online court is going to be called. It's not called the online court, but that's what it is. It ought to have a name, it ought to have a brand, like the Civil Resolution Tribunal. Shannon will show you slides, I'm sure, which have their logo, their name, their brand. What's wrong with that? The rather more important aspect of it, which I think is fairly clear, and this is something that Richard was talking about, is the way in which the system is designed. You've got a three-stage process to deal with typically online civil claims. Stage one is helping court users to understand the claim. Stage two is a mixture of conciliation and case management. And stage three is the decision stage. Now, that's the order in which you would go to court these days. But what Richard's committee recommended, perhaps counterintuitively, is that stage three of the online court, the judgment stage, should be delivered first. One reason for this is allowing judges to decide cases without a traditional hearing would immediately relieve pressure on the system. Another is that it would be easier to design and implement stage three than the other stages. And Professor Susskind's advisory group argue that stage three should be followed by stage two, which is the mix and conciliation and case management, and then by stage one, the decision tree process. Doesn't seem entirely logical, but when you think about it, it makes a lot of sense. But it doesn't look to me as if HMCTS has followed that. It looks to me as if they wanted to get the thing started, and I'm afraid to say it looks to me as if they were going for the low-hanging fruit. Now, I don't want to be too critical of HMCTS. That's not really what I'm here for. But I do want to just perhaps put what they're doing into a little bit of context. They have had a very difficult time. Ever since the general election nearly a year ago, there's been very little information from the government side, from ministers and from HMCTS, which Susan runs. There are two reasons for this. First of all, the government can't tell us, or maybe won't tell us, when or even whether it's going to introduce the legislation which it promised in the Queen's speech 11 months ago, and which Sir Ernest Ryder and the Lord Chief Justice regard as essential to the success of the reforms. Last Wednesday, the Justice Secretary David Gauke was asked by the House of Lords Constitution Committee when the bill would be published. He said it was a matter for discussion with the government's business managers, and then he went on and said this: I hope we can make progress on this before very much longer. There are a number of things we can do in this area which are non-legislative, but there are also some things which are best done in a legislative way. Without being able to give the committee a timetable today, I'm keen to make progress on that before very much longer. And when I asked him, when he was asked a bit about this by Lord Beith, he said, I would just urge, if I may, a degree of patience, further patience on this point. It sounded to me as if there was going to be government legislation. He was expecting to introduce a government bill at some point. I asked him about it afterwards, and the Justice Secretary told me, we're getting there. And that was it. But you'd expect HMCTS to talk to the media, wouldn't you? Because after all, they need to communicate with their stakeholders, and their stakeholders, the largest group of their stakeholders, are court users, litigants and potential litigants. And the best way to communicate with litigants and potential litigants is surely through the media. Now, unfortunately, that's not how HMCTS see it. Susan is very kindly saying that she's happy for me to tell her what I think about it, and that's what I'm doing today to try and help. But although she has these road shows, and there's another one in London next week, the only people allowed in are legal professionals or professional court users. So that rules me out. I'm not a legal professional, maybe a lawyer, but I'm not a legal professional, and I'm not a professional court user unless I'm trying to test the system. I want to talk about this tomorrow, but I thought I ought to mention it while Susan's here to give her a chance to respond. And you can understand the problems that HMCTS face, because although Susan has told you about all the wonderful things she's doing, I'm afraid to say that the reform programme is not going very well. That's clear from the report last week of the National Audit Office, which is Parliament's spending watchdog. It's independent of the government. Given the extent of the changes planned, it said, there's a very significant risk that despite the best efforts of HM courts and tribunal service and other parties, the full ambition of the change portfolio will prove to be undeliverable in the time available. I haven't put all this up on the slides, but nevertheless it's in the online version of my online book. I'll just give you a few quotes from what the NAO said last week. HMCTS faces a daunting challenge in delivering the scale of technological and cultural change necessary to modernise the administration of justice and achieve the savings required. It's responded to early concerns by extending the timetable and improving its governance and programme management, but there's a long way to go to achieve the planned transformation, and overall HMCTS is behind where it expected to be at this stage. And this is how the National Audit Office summarised its findings. HMCTS's change portfolio presents a very significant challenge, broader than those in comparable programmes in other countries, multiple stakeholders. It's changed its timescale and the scope of the portfolio significantly since 2016, went up from 4 years as a project to 6 years, but the budget didn't change. It's reduced the scope of the Common Platform Programme. Next one, delivering the reform successfully remains extremely challenging despite HMCTS's work to reduce risk. The revised 6-year timetable is still shorter than the time taken to complete smaller programmes in other countries. HMCTS has made less progress overall than it had expected to at this stage. A lot about interim states and rollouts and components and so on. The estates programme has generated, that's selling off courts, the estates reform programme has generated more income than expected. The programme at greatest risk of not achieving its outcome is a Common Platform programme. Expected costs have increased and planned benefits have decreased. There are gaps in the funding for reforms in later years. HMCTS has taken steps to improve governance and the way it manages a portfolio. HMCTS still needs to develop how the new services will work in practice. And then this business about the legislation delay in introducing primary legislation creates a significant degree of uncertainty. Failure to sustain commitment from all delivery organisations will significantly reduce the likelihood of success and the benefits achieved. Delivering change on this scale at pace means HMCTS risks making decisions before it understands the system-wide consequences. The benefits claimed so far by HMCTS exceed expectations, but risk putting pressure on its ability to maintain services. And those are the main heads of criticism. I can explain this in detail. The National Audit Office made a number of recommendations. HMCTS should allow enough time to engage with affected parties within the justice system, should resist pressure to claim savings until plan changes are fully embedded, should provide greater transparency of its objectives and progress and be clear how it's adapting its plans in response to the risk. It should work with the Ministry of Justice and HM Treasury to address the system-wide consequences of plan changes. So that's the challenge, and nobody can blame HMCTS for having this challenge. They didn't decide how much time and the breadth of this programme. Nobody's ever tried a programme of this breadth in any other country before. The problem is that they're trying to do it despite all this engagement with stakeholders and all the rest of it, and asking people who use the system what they think of it. They're trying to do it without telling us, the public, and you, the academics, what is going on in detail. And the National Audit Office has lifted the lid on it. The other party which has told us in a curious and bizarre way a week or so ago what's going on is the judiciary. As Ernest Ryder told you, the judiciary has written a number of papers. These have been sent to the judges. They're called Judicial Ways of Working 2020. And Ernest can tell you why that title was chosen. But they summarise, for the benefit of the judges, the people who've actually got to put all this into effect, what is going on. There are 4 different papers. They cover civil, criminal, family and tribunals, and they're all introduced by the Lord Chief Justice. They then have a second preface by the head of division, and they tell the judges what is going on, and they ask the judges to respond to an online survey. These have not been published. Perhaps it's not appropriate for the judges to publish them, but they're not secret. I've got copies here, and I can tell you in detail later what they say if you like. But I suspect I've run out of time. I suspect I've probably done enough damage. I probably ought to sit down now, and I'm happy to answer questions.
Thank you. Always a pleasure to have the grit in the pearl. But actually, you make some very important points. Susan said earlier that this was the most ambitious programme in the world. They kind of made my heart sink. And I go back to the point I made again, which Joshua just confirmed, and perhaps Ernest will as well, that when I talk to members of the judiciary, there is confusion at the highest levels, I think, about where we are at this moment, where we're going in the next couple of years and where we're going ultimately, what the trajectory is. And so I think, certainly for me, this conference, these couple of days and having you here was a really important opportunity for us to begin to get an understanding of where we're going, and your presentation was very helpful. And Joshua's right, there are some real concerns. The implications of such an ambitious programme are absolutely huge, not least in terms for the judiciary, who are having to implement these changes, or going to have to implement the changes. So anyway, thank you very much to all of our speakers. You've got an opportunity now. We've got until
Got a quarter of an hour.
we've got a quarter of an hour or so for questions. Richard, please come back. So if people would put their questions to say which panel member they want to raise a question to, and could you please say who you are briefly. I've seen that person over there. I'll collect you together. So 1, 2, 3, 4. Okay. Go ahead. Probably a good idea to stand up so that we can hear you properly.
Yeah.
So if that's not too
It's okay. So David Abrams, I'm from the University of Pennsylvania Law School in Wharton, and I have a question for Susan. But very interesting presentation. Looks like a lot is being done there. From a kind of theoretical perspective, do we think that increasing ease of access to courts is always a good thing? And so, just in some of the examples you gave, like divorce, there's a reason why the institution of marriage exists, and why it's costly and time-consuming and very public. And there may also be a reason that divorce is not so easy, at least historically hasn't been so easy. There are clearly downsides to that as well. But is it a bad thing potentially to make it possible for people to have a fight with their spouse and then what, this is it, click, we're done. And you can imagine problems with other areas as well, where disputes kind of get escalated very quickly, and a better way to resolve it might be privately rather than getting the judicial system involved.
So, just to reassure you, on divorce, we haven't changed any of the underlying law, so you still have to, before you can click, you do still have to wait 2 years in most cases and demonstrate that you've got good ground. So the bit that we're making simpler and easier is simply the bit where you fill in a form. And my own view is that we shouldn't be using process complexity as a way of managing or gatekeeping access to the legal process. If we think there are things or places where you should be going through other stages or steps before you have recourse to the system, we should build that in, but we shouldn't do it by making the thing arcane and hard to navigate, because actually it doesn't work. That restricts access to some people far more than others.
So are you all trying to do that simultaneously? Because, and I think that's a great answer, but would you be concerned if you did, say, lower the barriers to kind of universally, which could have heterogeneous impacts across people, but without kind of the legal reform that you would want to address some of those reduced barriers?
I think I put it the other way around. So I think as I say, I'm not in the business of thinking that making the divorce form simpler is such a massive change that we need to make people wait an extra year before they can use my simple form, for example, if that's the sort of suggestion you're making. I do, however, think that, I mean, as we've tried to do in the civil money claims system, actually, as you try to make the barriers to entry lower, you do have to think about what it is people are entering and how they're going through the process in stages. So, as you saw in the system, we have given some quite big signposts to people to say don't come through the system unless you've actually tried to talk to the other party and sort it out between you first. And it asks you to consider mediation and other forms of resolution before you go through the system. And I do think there's something about trying to consciously think about people's path, not just digitise the existing process, which is fundamental to the way we're going about it anyway. But I mean, by and large, I think
people are used to clicking. You know, how many user agreements have you clicked through this morning?
I'm going to cut you. I'm going to cut this one off now. You can fight about it later. Over to you. Can I? Who's it? Right. Yes, over there.
Richard Miller from the Law Society. I think there's a lot in what we've heard that sounds like it can make the system a lot more efficient, a lot more user-friendly. But one of the things that I felt listening to the presentations today is an underlying assumption that we are dealing with two parties who are in good faith in dispute with each other, whereas very often the issue is that there is one party that is dominant, has much more power, and is deliberately abusing that power to basically reach a mighty right solution rather than a just solution. And I just worry slightly that some of the reforms may risk giving more power to those who are being deliberately obstructive. And I was wondering what assurance you can give that that's being addressed.
I let Richard answer that first, and then maybe.
Mine's a bit, it's very strange you say that, because I think entirely the reverse. I've always thought so, that this is a way of levelling the playing field. Seems to me, when you see the kinds of mechanisms we have in mind, and also to combine it with what Ernest was saying about more active, essentially more active case management, then that would, in fact, empower those who hitherto would have less insight and would be in the back foot, and would perhaps discourage those who are in a powerful position from exploiting that position. You asked for assurance. I think that's the spirit with which most of us are progressing. So intuitively, and remember, I have to stress this for everyone to relate to what Josh was saying, it is still very early days in all of this. In my own, I'm interested in two ways. One is what we're doing in England and Wales, but my bigger interest is over the next 30 years how our justice system will change. The point of this meeting is to be asking the right question jurisprudentially and critically about the evolution of these services. So there's going to be a lot of trial and error. There's going to be, we just have to accept that we'll be experimenting, piloting, refining as we go along. But I've never seriously thought that what we envisage would disadvantage the less well-off, because certainly our original group are the less well-equipped. Our original group was really designed to think about the reverse, was how could we empower those who otherwise are excluded.
Susan, you want to comment on this?
Yes, I mean, my starting point is to agree with Richard that I think this gives I think this actually tends towards the levelling of the playing field, but I do think it's a thing that it's worth giving us some attention to, and I think there's a couple of ways in which we are doing that. So we're looking quite carefully at the early feedback and data that comes out of the system to see if we can see patterns. So in other words, are we bringing new people into the system who otherwise haven't used it? Are we seeing people trying to kind of use systems to exert main force over others in a different way from the way that they have done in earlier paper-based systems? And we're also looking at some very specific cases. So one of the things that we know occasionally happens in the existing system is, for example, that controlling and abusive spouses or ex-spouses will bring civil actions against their partner effectively as a form of harassment. Now that happens in the system now, but we are looking at whether there's a risk that we make that easier for people to do by having a gateway. We've got no evidence that we have made it easier, but what we have done is made it rather easy to detect, because we can see rather more easily in the new system whether there are patterns coming through, and we can also, where it's appropriate to do, and there's a whole world of could versus should in some of this, I think, but where it's appropriate to do, if we have people who have exhibited that pattern of behaviour in the past, we can effectively person flag them so that if they come through the system again, we can identify and try and manage that. So I think there are. I don't think it's inherently more likely in the system. I do think the system gives opportunities to detect and manage it, but it also gives really good opportunities for us to see those patterns on a wider scale.
Can I just quickly ask Ernest on this? Because Ernest, in your neck of the woods, people are dealing with the system and the state. So what's your view on the extent to which this empowers people?
Three answers that have to be borne in mind within the overall context is, until we have the data to analyse, that this is work in progress. So nobody can say with clarity that there is an answer to the question that Richard raises. But the first is that we are replacing paper with a digital process. Judges are no more able to determine people's power broking on paper than they are digitally as a start point. So it's not as if the digital process is going to damage something that is already a beacon of excellence. Far from it. It's going to give you the data to be able to see things you presently can't see. The second aspect is judicial training. We don't train judges to determine the person who should be excluded from the judicial system by looking at paper. We do it by training them to look at unconscious bias, to look at the way in which they evaluate people in court, the way in which they determine credibility and reliability. And what I've said, and I make it very, very clear, just as the governance of the judiciary has to change to facilitate the digital system, so does their training in how one deals with part digital or complete digital services in the justice sector. And the third element is there's a fundamental misapprehension underlying the question. If you're dealing with contested probate, contested family relations, for example, for the removal of a child from a parent or into care, if you're dealing with serious commercial reliability and credibility issues or a criminal jury trial, who has ever said that we're going to put the whole of that into continuous online messaging? I haven't, the chief hasn't. You're reading that into the document, it isn't there.
Thank you. And just to say that we have a whole panel dealing with judicial training tomorrow, because we recognise that is a very big issue. Natalie.
Just quickly, thank you so much for those. Absolutely fascinating. It's really great to hear from you, Susan, that the data strategy is being developed, and great to hear from Ernest that data is going to be embedded in the systems. I wondered, one thing that would really sort of help the organisations that we at Foundation represent is to understand whether there are plans to embed upfront the collection of demographic inequalities data on the people who use the system, so that we can improve transparency and accountability and identify whether the move to online processes is creating disparities for particular groups.
Thank you. So this is a question that I get asked quite a lot, and I think it's worth just taking a step back and talking about why it's even a question. And it's even a question because we're building all the systems trying to use best practice in terms of the things that make them usable and easy for people to find their way through. And we also apply, and I at some stage I'd quite like to respond to some of the questions that Joshua put. But whether or not you think the branding of .gov.uk is appropriate, and certainly I think that you make a very valid point, and it is one that you and I have actually discussed before, and it won't necessarily surprise you to learn that the process of making a decision on that point is a slightly extended process, but it is something that we are actively looking at for exactly the reasons that you give. So I have not ignored you. But plus there are other people who, I mean, it's a widely held view that this is something that we should look at. Indeed, it's held by me too. But whatever you think of that, I think the Government Digital Service has some really good principles for how you build really accessible systems that work. And one of their principles is that you never ask people a question that they don't need to answer in order to get through the process. And if you apply that principle rigidly, then you don't ask people a whole load of stuff about their demographic data in order for them to submit a claim or get divorced, because they don't need to answer the question in order to go through the process. Now, from a research point of view, that I can see that is the wrong answer. So one of the things that I'm asking my staff to do is to think about what the ways are of squaring that circle. And exactly. And I think looking at how you could randomise or ask a statistically significant sample for their demographic data, so that you are asking some people but you're not asking everybody to provide everything, may well be the way we get through that, and that's what we're looking at internally at the moment. So the principle that I want to establish is that we will do something that allows us in a robust and statistically significant way to understand the demography of those passing through the system and their outcomes, but I'm not necessarily going to commit that we collect every piece of demographic data possible from every person going through the process in order to do that, because I think that might actually hit our usability, which is the other thing I've got to balance.
Can I, just before we go to the next question, I think I ought to give Susan a brief opportunity, if she wants to take it, to answer some of the points that Joshua made.
Yeah.
I don't know if you want to pick out any in particular.
Yeah, I mean, I'll try and do the lot, but we'll see how I go. So I think, so very quickly, should we be hosted on .gov.uk? Does that branding help? I think that's a well-made point, and it's one that we're looking at, but I can't say anything else about it because, as I say, I've got to go through a process of convincing a whole load of people, including a bunch of government ministers, that that's the answer. Anyway.
The judiciary will support you in changing that.
That I know. I was trying not to set up a ministers v judges fight in this session. But I think it's a well-made point, and we need people going through the system to understand the separation that there is in the Constitution between the judiciary and their judicial decisions and the rest of the state. I think that's really important. Them and her, this is based on the advice that we have been given on, and it's, again, I read it as clunkily as you read it, and I know it's difficult. It's based on the advice we've been given on making sure that we are being as open and diverse as possible, and it reflects the fact that we may have people who are a wife but who have gone through gender transition process or may identify otherwise than in a gender binary way, and the use of the word them reflects all of that. Now, I know it's possible to have all sorts of different views about that, but that's why it's there. And again, it follows GDS guidance on best practice. Three-stage process, I think this is quite an interesting one, and I'd be interested in Richard's reflections on this to some extent. I mean, the original conception of the three-stage process for the online court was, as you described, that there would be a first stage that was built on a set of decision trees that helped you to navigate and construct your problem, and then effectively a kind of mediation, dispute resolution, ODR stage, and then there would be a stage in which the judge was supported in order to make decision-making online. And I think what we've done is develop and refine our understanding of all three stages, and to some extent the examples I gave and showed demonstrate us developing all the three pieces of that puzzle in different ways at the same time in different jurisdictions, preparatory to being able to bring them together in different ways in order to address different kinds of dispute. And I think we may want different blends in different jurisdictions. So stage 3, I think, is, roughly speaking, what we are doing through that continuous online hearing bit that I showed at the end. And,
If I can just help, the SSCS trial that you were shown by Susan does follow Richard's hypothesis, and so it will enable us to do early adjudication, and where in effect the government decision maker is on any basis wrong as a matter of law, wrong on the facts, or frankly was so inapposite in the way in which they put the decision letter together that they should be said to be wrong because the reasoning is there. Why shouldn't we adjudicate those early and send them back? And actually where we've got to, and that's the bit that Susan was able to demonstrate to you, when we trial it, will now enable us in a pilot to do just that. That takes down the determination for the person out the benefit on which they need to go to days instead of weeks. That's a really worthwhile objective.
Can I?
So to some extent, I don't think we are not using the insight from the group. I think we've just.
Let me just give you. I'll give you 2 minutes on that. The recommendation that Joshua refers to was not in our original report. It was in our letter. I still stand by it, but it's our letter in response to Lord Justice Briggs's reports. And the reasoning behind it's not a matter of principle, it's just a matter of pragmatism, is that we were then and remain now very keen to get on with the project. And if you spend too much on stage one, the decision trees were more Lord Justice Briggs than our recommendation. We thought, well, we're never really going to get to the very important bit. Is quite a lot of cases don't need people physically to congregate, so wouldn't it be quite good to get on with that? And that crudely was the approach, and that's why, and Ernest and I met the other day, we were talking about it, that's why I was cheered to hear that. There is no best way of going about this, but my own particular preference is that the debate changes from, is this going to happen, to how can we best make it happen? And it seemed to me that the quicker we actually get some judges making decisions online in one way or another, the easier we can convince the community that this is a question of making it happen in the best possible way. Because I am 100% convinced, I don't know if it's 1 year, 4 years, whatever, but this is going to happen. So I want to help bring about, as Mark said, help bring about the inevitable. That's what you actually want here. And so precisely what the Tribunal Service is doing, I think, is a good thing. I just want to see as many judges engaging as soon as possible.
Well, we're running into tea time, but I just wanted to give Susan an opportunity just to answer the question, that the really rather tough criticism that this was an over-ambitious project which can't really be delivered and is actually behind. And what to say to that?
I mean, so I thought the NAO report was quite helpful, but that's because I've seen a lot of NAO reports in my time, and this is one of the more positive ones that I mean, it's sort of their job to tell us what's hard about it. It's a really ambitious project, and I said that up front myself. We're trying to do an awful lot. Some of the aspects of what the NAO have said relate to the shift from a 6-year programme, from a 4-year programme to a 6-year programme, which happened before we'd started. So as we spec the programme up, it was spec'd as a 4-year programme, and internally in the conversations around government, there was challenge to that, and stating that's going to be really hard. I think you should rephase to a 6-year programme. And that is the moment at which the biggest shift in costs and benefits happened. So when the NAO say the costs went up and the benefits came down, the biggest chunk of that happened when we shifted from a 4-year to a 6-year programme. And it's sort of inevitable when you do that, because doing something for 6 years costs longer than doing it for 4 years. And your benefits come later than if you were finishing everything after 4 years. So there's a sort of a part of that is just a description of us having decided to move from a 4-year to a 6-year programme. It's also completely true that we have not done absolutely everything that I wanted to do by this point, and that the main NAO field work was done in September, before we had delivered all of the public betas that I've just described as well. And if you go into the detail of the NAO report, they will say that in September we'd set ourselves a whole lot of milestones to reach by September, and that we'd fully completed about 60% of them, and about another 25 to 30% we had part completed, or we decided that we were going to shift slightly what we were doing and completed the different thing. Now, and that left a very small number where we'd not done it and we thought it had a material impact on the future of the programme. Now, if I worked in the NAO, I would say, look, you're way behind and you haven't done everything that you intended to do. 60% is a lot less than all. But my contention is that in a programme of this scale and complexity, having completely completed 60% of your milestones and have another 20% or so that you've done to a significant extent, or enough that you don't have to do something else in order to remediate it, is reasonably good progress. And when you, there's always a choice. You can set yourself ambitious milestones and ambitious timescales, and then you know that you're unlikely to meet 100% of them. Or you can set yourself significantly less ambitious milestones and be more confident in meeting them, but make slower progress. And I'm afraid I've always been a person who goes for the first option rather than the second option, and that will always mean that I get some challenge in audit and reporting, and I sort of have bought that as a bit of territory that comes with what I do. I'll be quiet in a minute. I think there's just one other thing. It is really important, and Joshua did read some of these pieces out, it is also really important that the NAO has recognised the work that we've done to improve and strengthen our governance of the programme, the way that we're running it, and they have been quite positive about that in the report, including, to my eternal astonishment, a direct quote from Amos Morse saying that we put a whole set of things in place that have improved our ability to deliver. And I don't want to go too much to town on this because there's lots for us to do in the report, but they don't always do that, and so I took that as an important testament to the work of lots and lots of people in my team who have worked really hard to do that. The final area is the area around making sure that we are engaging more widely and talking to more people about what we're doing, and that comes through in the NA report, and there's also another reflection that you made. And I think we've got some particular challenges in getting ourselves, I'm going to use the word authorised, to go and talk really widely to the media about what we're doing, because there are bits of this that people get nervous about, and also because there are various things in the political context that mean that people get nervous about it. I would like to get to a point where we can do much more of that, and you know that, and we've talked about it before, but I also want to make sure that we are talking as directly as possible to users of the service, and there are not that many people out there who self-identify as users of the justice system. People quite often only use it once. So they're not really like passengers on trains or even parents in schools who kind of for a period identify themselves as that type of sort of user. And so there's something about this focus on actually using real people who are using the system to test and iterate what we're doing with that. I think it's got to be at the heart of what we're doing. We do also have to explain more widely, but if we're really, really focused on putting the user at the heart of the system, I think the most important thing is that direct first-hand commentary from them. And we've had, I think we're now north of 6,000 people going through pilot systems and giving us feedback on them. So we can do more, we can engage more widely. I want to do more. I'm doing as much as I can with legal professionals because I can get authorised to do that. I'd like to talk more widely to the public, but I do sort of mildly reject the thought that I'm not talking to any court users, because I've got, as I say, north of 6,000 of them who have got direct experience of what we're doing, given direct feedback which we've responded to and built into what we're doing.
Thank you for that, Susan. It's 20 to 4. We've now got 20 minutes for tea, and we're going to start again at 4 o'clock. But before you leave, can we please thank again the panel for outstanding